years later, in a 7-judge bench in Vishnu Agency's case, Chief Justice Chandrachud speaking for the bench, agreeing with Justice Hidayatullah and setting aside the majority. Another great judgment, again a dissent in the early days, is in Re-See Customs Act, another very interesting case. That case involved the interpretation of Article 289 of the Constitution. Now, 285 and 289 are two sides of the same coin. Either the union is exempt from state taxation or vice versa. Over here, the question was whether the union could levy customs and excise duty on the states, state being a state as such, the state of Maharashtra, for example. The answer given by the majority was yes, it could, because 289 only spoke of direct and not indirect taxes. Justice Hidayatullah dissented, and in my view correctly. He said, it is well settled that we do not know any distinction of direct and indirect in our scheme of taxation. Taxation is in fact defined by our constitution to mean X. And it must bear that meaning. And if it bears that meaning in 289, it is obvious that the union cannot succeed with such a levy on the states. Also, interestingly enough, in that judgment itself, Justice Hidayatullah then went on to say that look at the language of the article, and that will tell you whether the majority is right or wrong. The language is clear. It is income and property. Taxation that is relatable to income and property. Now, income is something that is contained in entry 82, list 1, 7th schedule. Therefore, an income tax was conceived of as something that Parliament could lay down. But what about property tax? All property taxes are in list 2, Hidayatullah pointed out, correctly. To this, the answer given by the majority was that that may be so, but suppose you come to a union territory. They were driven to this kind of reasoning. In a union territory, Parliament can use the state list as well and therefore can tax property. Now, obviously, this stretched reasoning, which is the majority judgment, did not find favor with Justice Hidayatullah. It continues to be our law, but I don't know whether his brooding spirit will someday ask another bench to review this. Another very interesting judgment in the 1960s is the judgment in Bhagwan Das Kedia. Now here again he was in dissent. And here the question was, where is a contract said to be complete? And the contract here was made on the telephone. Is it complete in Ahmedabad, where the acceptance was sent, or is it complete in Khamgaon, where the acceptance is received by telephone? The majority judgment said that Section 4 will not apply to a transaction like this, Section 4 Contract Act, because the section says that a contract is complete as against the acceptor when it is put into a course of transmission to the proposer. And that, of course, the illustrations showed that the section would apply only where a third party intervened between the two, the post office, for example. And the majority therefore held that there is no post office. Once there is a telephone contract, it's as if you are face to face. And if you are face to face, obviously it's only when you receive the acceptance that the contract becomes complete. And they followed Lord Denning's judgment in the Entos case, in which, in a similar situation, Lord Denning put it very picturesquely that you have a river and you have somebody shouting an offer across the river to somebody else. The person who accepts the offer says something, but it can't be heard by the offerer because it is drowned out by a thunderstorm or by a helicopter or something or the other. Is the contract complete? Answer given was no, it's not complete. But Justice Hidayatullah went into the ultimate detail and reviewed the law of so many countries and found ultimately that the countries could be divided into 3 groups. One which had the Entos type, where only acceptance and reception would form the contract. One which had the Section 4 type, which is the acceptance being put in the course of transmission. And one which had a combination of both, and which said it related back to the acceptance being made. And ultimately what the learned judge held was, sorry, we have a section, no doubt it's an 1872 section, no doubt the telephone has come in 1876, 4 years after, when Bell discovered it. But when we have a section which says something specific, we have to follow it, and follow it specifically. We now come to two very interesting judgments of Justice Hidayatullah, the obscenity judgments. In Ranjit Udeshi in 1965, he was faced with D.H. Lawrence's book, Lady Chatterley's Lover. And the question was, there were lurid and steamy sex scenes in it, whether it would pass the censorship muster under Article 19(1)(a). Justice Hidayatullah, being conservative, decided to follow the old Hicklin test, which was an English test, and which said that anything which appeals to the prurient interest in persons not fully mature like ourselves, and which therefore titillates them, is something that cannot pass muster. And in doing this, of course, he went into a whole lot of literature. He in fact started with the beginning of the obscenity law in England, tracing it to some well-known rake in the time of Charles II, a man called Sir Charles Sedley, who bared his bottom on the first floor of some tavern, as a result of which there was some action in the common law courts, and the tort of obscenity came to be known as obscenity law. Interestingly enough, in this judgment, he didn't refer to Kingsley's case. Now, Kingsley's case was a judgment delivered by Justice Douglas in the United States Supreme Court, where the very same book, Lady Chatterley's Lover, passed muster. In doing so, Justice Douglas adverted to our Constitution. This is very interesting, that even US judgments advert to our Constitution, and said that unlike our 19(1)(a), their First Amendment is absolute and says Congress shall make no law. Shall make no law means closed, affecting freedom of speech. Whereas if you look at the Indian Constitution by way of contrast, it says, yes, you can make a law with two provisos. One, it must be with respect to one of the 8 subjects enumerated in Article 19(2), and second, it must be a reasonable restriction. So interestingly enough, Justice Douglas, who, as I told you a little earlier in this speech, had come here and had delivered this lecture in 1956 from Marshall to Mukherjee, had obviously studied our Constitution with good effect and used it to promote his point of view in Kingsley's case. But Kingsley's case was referred to in the next famous obscenity judgment in K.A. Abbas, again decided by Hidayatullah, this time at the fag end of his career in 1971. Now, in Abbas's case, question was whether censorship of films could be allowed or could not be allowed. And here the learned judge, being conservative, said, yes, of course it can be allowed, and gave various examples and citations world over. One of the interesting things he said in the course of the discourse in Abbas's case was that even though we follow Hicklin's test, which is a conservative test, yet if there is some great artistic value in the work, then it can pass muster. And here again he gave very interesting anecdotes from English literature. He went into Voltaire's Candide, the rape of Cunegonde. He went into Oedipus Rex, for example, where Oedipus finds that he has slept with his mother, not knowing that the lady is his mother, and then puts his eyes out. And despite the fact that there are lurid love scenes in all these books, they may pass muster because of the literary value. Where Justice Hidayatullah really scored, in my opinion, was in the famous and celebrated Golok Nath case. Now, Golok Nath concerned something which touches us in our everyday lives. Because Golok Nath was concerned with whether Parliament was supreme or whether the fundamental rights given by Part 3 of the Constitution are supreme. A very early judgment in Shankari Prasad went into the very question, namely, as to whether a constitutional amendment passed by the requisite two-third majority can be struck down on substantive grounds. Answer given was no. Can only be struck down on procedural grounds. For example, the requisite two-third was not there, or that even if it was there, it was less than half the total number of the House, or that it was not ratified if it required ratification by at least half the states, or some such thing. This was given a fresh look in Sajjan Singh's case, years after, by Justice Hidayatullah and Justice Mudolkar. The latter of whom, interestingly enough, used the word basic structure for the first time in 1965. And by the time we come to Golok Nath, we had a bench of 11 judges, which was the entire strength of the then Supreme Court. By a razor-thin majority of 6-5, because of Justice Hidayatullah, who was the odd man out, ultimately it was held by 6-5 that what has happened has happened. We can't go into it now. But for the future, you cannot touch the fundamental rights chapter. Five learned judges had a reasoning completely different and opposed to another 5 learned judges. It is Justice Hidayatullah's reasoning alone which stood out. And it is he who made the majority of 6 versus 5. First and foremost, Justice Hidayatullah said, a constitutional amendment cannot be grounded in any specific article of the Constitution. The majority grounded it in the residual power. The minority grounded it in Article 368 itself, which stated procedure for amendment at that time. Justice Hidayatullah said, no. Amending the Constitution is sui generis. It's a sui generis power. Again, he used the Latin expression. And since it's a sui generis power, it cannot be founded in any of these articles. It is something that inheres in a constitution. Otherwise, you have revolution. So this is the first important point he made. The second important point he made has somehow been missed in every single judgment thereafter, including the judgments in Keshavananda Bharati, which came after 6 years. He adverted to a little-known article in our Constitution, Article 35. Now, Article 35 reads as follows. It says, notwithstanding anything in this Constitution, this is important, begins with a non-obstant clause. Notwithstanding anything in this Constitution, Parliament shall have and the state legislatures will not have, so it is put affirmatively and negatively, the power to make laws in respect of certain specified subjects, one of which is laws made under Article 33, which can curtail fundamental rights for the armed forces. Now, he pointed to this article and said, this non-obstant clause obviously overrides everything, including 368. And because of this non-obstant clause, state legislatures can never make laws under Article 33. So this is one example of an article which is beyond the amending power. This was a very important point he made. Somehow or the other, it was never picked up later. Now, in the US Constitution also, there is one particular article which is unamendable. And that article is that each state will have at least 2 representatives in the Senate. That cannot be touched even by a majority of 3/4. Similarly, our Article 35 cannot be touched. And therefore, he made a very important point. He made the point that there are certain articles and therefore there are certain things that are unamendable. And if there is something that is unamendable, like Article 35, then it is clear that fundamental rights which are so important to a democratic nation should be held to be unamendable. Of course, you all know the constitutional history that followed. Keshavananda Bharati overdid the majority, overruled the majority in Golok Nath, but laid down a test which stated that you cannot, Parliament cannot transgress what they call the basic structure of the Constitution, so that if an amendment is made contrary to what a judge thinks is the basic structure, that amendment will be struck down. This has been used very often. to strike down constitutional amendments on substantive grounds. And we find now in the recent Coelho judgment in 2006 that 9 judges have almost come around to Justice Hidayatullah's view in Golok Nath. I say almost. Why do I say almost? Because Coelho first laid down a very important proposition. All fundamental rights form part of the basic structure. This had never been laid down before. Now, if all fundamental rights form part of the basic structure, it must follow that a constitutional amendment that is put into the 9th schedule to emasculate these rights should be held to be bad. But then it didn't follow, because the judges went on to say there's a 2-tier test, not a 1-tier test. First, you must see whether the law violates a fundamental right, which has already been held to be part of the basic structure. Second, you must see whether it violates the basic structure itself. And it's this second test that has moved us away from Golok Nath and Justice Hidayatullah's great position that he took in those times. There are so many other judgments that come to mind. It's very difficult to go on and on like this. But Shri Prithvi Cotton Mills is one judgment of Justice Hidayatullah, where he lays down a separation of powers doctrine, and in which he says that though a legislature cannot ever interfere with a judgment directly, it may do so indirectly by retrospectively changing the law and therefore the basis of the judgment. In Dhulabai's case, he laid down in those 7 famous propositions as to when a civil court's jurisdiction will be excluded. In the famous Privy Purse case, which was one of the last judgments that Justice Hidayatullah ever wrote, he struck down a midnight order where the prince's privy purse was taken away. There are so many illuminating and outstanding judgments, but the great thing about both these judges was that they didn't stop merely at the law. They brought to bearing a great deal more. They brought to bearing not only learning, but life itself. And I can only end now by telling you that if we were to have an opinion poll to ask us, who are our 5 greatest judges that the Supreme Court has ever had since its inception, I would have no doubt whatsoever that both of them would feature. And that's saying a very great thing, because both of them came from here. And with that I end. Thank you all very much.
Thank you, my lord, for such an elucidating lecture. If I may tweak the quote from Dickens to sum up our collective feelings about my lord's lecture, this was the best of times, this was the age of wisdom, this was the epoch of belief, this was the spring of hope. Thank you, my lord. I request Advocate Arun Patil, President HCBA, to present a small token of our appreciation to Honorable Shri Justice Rohinton Nariman. I request Advocate S.V. Bhutada, Secretary, to present a memento to Honorable Shri Justice B.R. Gavai. I now request Advocate Bhutada to kindly propose the formal vote of thanks.
My Lord Justice Rohinton Nariman, My Lord Justice Bhushan Gavai, Honorable Judges of the Bombay High Court, past as well as present, other Honorable Judges, the learned Acting Advocate General of Maharashtra, Shri Rohit Dev, the Advocate General of Chhattisgarh, Shri Jugal Kishore Gelda, the Government Leader at the High Court, Mrs. Dangre and her team, learned senior counsels, members of the bar, Mrs. Nariman, Mrs. Bobde, President of the District Bar Association, Mr. Jaiswal, ladies and gentlemen, as we draw the curtains on this yet another edition of late Advocate N.L. Belekar Memorial Lecture Series, I must revisit the memory lane and acknowledge our learned predecessors in the High Court Bar Association who were instrumental in the genesis of this wonderful event. A sapling which was planted in the year 1997 by my guru, Mr. Vijay Daga, as his lordship then was, and which over the last several years has been nurtured carefully by the subsequent office bearers of this association, has flowered into one of the most awaited events in the academic calendars of this city. In the same breath, on behalf of the Orange City's citizenry, I bow down to Advocate Shri M.N. Belekar, without whose unshackled philanthropy this venture would not have taken off at all. My profoundest gratitude is reserved for my Lord Justice Rohinton Nariman, who graciously accepted our invitation and has today delivered a truly memorable exposition of thoughts on the invaluable heritage of this city and region. Sir, I must candidly admit, your words have acted as a redemption of sorts. Such reminders help bridge the yawning gap between the younger generation and the heritage, something that is of vital importance to the legal fraternity and to the society at large. Thank you, sir, for treating us to an intellectual feast. My Lord Justice Gavai, you have been our guiding light. Whenever we have needed your support, without slightest of hesitation, we have been able to access you despite the high office you hold, and you have resolved each of our issues almost as if you wield a magic wand. I am sure, sir, not a single black coat in this gathering will disagree with me. Thank you, sir. A big thank you is due to each learned soul in the audience. Honorable judges and members of the bar, your wholehearted attendance and participation is the inspiration that makes us work harder and do better while organizing such brainstorming sessions. I can see quite a few non-lawyers in the audience, many budding lawyers too. This enthusiastic response clearly speaks volumes about the popularity of the day's orator and leaves no doubt about the magnetism of his persona. The High Court Registry deserves a special mention. Without their support, this event would not have fructified. While I conclude, I am reminded of a shloka which reads thus: Mahajanasya sansargah kasya nannoti karakah padmapatram sthitam toyam dhatte mukta falashriyam, which translates thus: for whom is the company of great people not beneficial? Even a water droplet, when on lotus petal, shines like a pearl. The ageless edict aptly embodies today's lecture. Thank you, one. Thank you all. Jai Hind.
Thank you, sir. I now request everyone present to kindly rise for the national anthem.